Hey everyone, Kaosy Umeh here, aka Attorney Know It All. Thank you for coming back with me here today. And today, I'm back again in 2025, trying to bring more videos to you every day. So today, we're going to discuss whether or not you have to lose everything when you get divorced. So that seems to be the major concern I have, especially when I get clients in a certain income bracket level. And especially the men, they're very worried about whether or not they lose everything, if they have to give half of their income or half of their wealth to their wives upon their divorce. So I don't believe that's necessarily true. One way to avoid having to pay off your spouse all this money during your divorce is to attempt to get custody of the children, or at least getting 50% custody of the children. So, in a 50-50 situation where both parties are working, it is very unlikely, especially if you make close or roughly around the same amount as the other party, it's very unlikely that you're paying a crazy amount in child support. So, by that I mean in a family of four, two children, two working parents, father earns maybe 100,000 a year, mother earns maybe, I don't know, 85,000 a year. In that situation, in a 50-50 custody situation, if they're doing 50-50, if father does have to pay mother alimony, ooh, why am I speaking of alimony? If father does have to pay mother child support in that case, father is probably not making more than $200 a month in child support payments. And even that might be a lot. Um, because child support is determined based on how many nights the children are spending at the person's house, and also looks at the income. Maryland has a calculator, and one of these days I'm going to take you through the calculator and give you a fake case, and we can estimate how much each party will be liable to pay. So that's one way to avoid having to, at the end of your divorce, having to pay out your spouse all this money. The second thing to do, and in this case is to avoid alimony, is to remember again, Maryland is not a very alimony friendly state. In Maryland, if you're young or youngish and you can work, you can go out there and build a financial security for yourself. The courts don't really understand why it is you need someone else to take care of you. So in Maryland, we have rehabilitative alimony, and we have permanent alimony, and we also have temporary alimony. So rehabilitative alimony tends to be done for people who are married and they were stay-home spouses. It's mostly stay-home wives because there are not a lot of stay-home fathers. But usually, mostly stay-home mothers. You're getting divorced. You spent the last 10 years of your life outside the workforce, but taking care of your children, taking care of the home. And now you're getting divorced. You have no money. You have no work history. You need to be able to take care of yourself. The degree you got when you graduated from college before you got married, things have changed. Let's say you got a degree in computer science. We all know computer science from 10 years ago as compared to computer science today, not the same thing. So you need to go back to school. You need to re-educate yourself. You need to learn some new skills. That's what the court calls that's when the court considers rehabilitative alimony. So in Maryland, there is a cap on how long you can receive rehabilitative alimony, and that's a period of 5 years. In Maryland, they say 5 years. Well, 5 years is literally enough for you to go back to college and get an undergrad degree and move forward with your life. So 5 years is the max the court is willing to offer rehabilitative alimony. And then the amount is what we fight about, how much we allow during this 5 year period. And excuse me, just because 5 years is the cap, the max the court can order in rehabilitative alimony, does not mean they will always order 5 years. I've had alimony cases where the courts only offer 1 year of alimony or maybe 2 years of alimony. It doesn't have to be 5 years. The one thing about rehabilitative alimony, your spouse has to already be in school or be in the process, prove that you're in the process of actively getting recertified or re-educated. They cannot just come to court and go, oh, well, after the divorce, I plan on going back to school. It's too late then. If you haven't already started school, started getting re-educated, it's very unlikely the court is going to say, yes, let me go ahead and award you alimony for something you might do in the future. So there's really no way to prevent rehabilitative alimony if a person is in school and they actually do deserve it. But it is something to look out for. If you do have a spouse who's telling you, oh, I want a divorce and I plan on going back to school, remember that if they're not back in school on the date of court, and you don't have to remind them, I would actually recommend you do not remind them. But if they're not actually back in school, they haven't yet registered, they don't have proof of their registration, your attorney needs to remind the courts of that, or needs to remind the courts of the law. The whole purpose of rehabilitative alimony is to help the parties seeking it to transition and to rehabilitate themselves, but they have to be in the process of rehabilitating themselves. So that's one thing. That's one way you might be able to avoid alimony payments. Permanent alimony is so in 2025 Maryland, and each year it gets worse. Like as we go further up in years, the courts are more and more unlikely to award permanent alimony to anyone, because the fact is you have to show the marks you have to clear just to receive permanent alimony is so high. Now, if you're getting divorced after 50 years of marriage and you've been a stay-home wife for the whole 50 years of marriage, yes, in that case, you're probably going to end up getting permanent alimony for however long you may have on earth, or until you remarry. But if you're, I don't know, you've been married for 20 years, you're getting divorced, but you're still in your 40s, you're still at least 20 years away from retirement age, or even 10 years away from retirement age, there is no way in Maryland courts, and you're healthy, you can work. Yes, you've been a housewife the whole time you were married, but you're still youngish. It's very unlikely the courts is saying, oh yes, let's grant you permanent alimony. That just doesn't happen that often these days. You see old alimony, you see clients who come in attempting to modify their alimony agreements, and they have permanent alimony, but for some reason they want to raise the price. They want to raise how much they're receiving each month. And I always have to counsel them, like, I wouldn't touch this. You're only 50 years old. If we take this back to court, the court is just as likely to remove the whole alimony than they are to actually raise the amounts you're receiving each month in alimony. So permanent alimony is really going by the wayside in Maryland. Again, for that woman who's been married, who's 70 years old, been married for 50 plus years, and she is seeking alimony, she's probably going to get it because her age, her health, the length of their marriage, children in their marriage, things of that nature. Those things will qualify her and put her past the hurdle of that permanent alimony bar. But we don't get a lot of those these days anymore. And again, courts are less and less unlikely and less unwilling to allow permanent alimony when you're young enough to provide for yourself, and you're young enough to go out there and seek rehabilitation to be able to provide for yourself. Courts just believe that if you're able to take care of yourself, you should take care of yourself. That's where we are with the alimony laws in Maryland. So I say all this to say that just because you're getting divorced doesn't mean you have to be paying an exuberant amount each month with your soon-to-be ex-spouse, simply because we're married. So we've covered alimony and child support. Those tend to be the two biggest payouts in a divorce. But the other things people also worry about are their property. So you have a house, you have a car, you have a vacation house, you have other tangible items, and you're worried about what's going to happen to them in a divorce. So the key thing to remember is that Maryland is an equitable distribution state. We're not a communal property state. And the big difference is that in the communal property states, whatever you acquire during the marriage is considered marital property. And during the divorce, the courts are more than likely to split that up 50-50. And that's what it is. In an equitable distribution, as we are in Maryland, equitable distribution states, The courts also take the same approach as in, okay, whatever it is you purchased during your marriage is technically marital property, unless, of course, there's a prenup, and that's for any state. Um, but assuming there's no prenup, whatever you purchase in your marriage is marital property. And yes, the courts in Maryland are still likely to just put it all in a bundle. They make everybody complete to 9-207, which is a joint marital statement to state all your assets. So the courts put them all together and they divide 50-50 among the parties. Um, but the difference, and I know you're saying, well, how's that different from communal property? The difference here is there are factors the courts can take into consideration that will turn that 50-50 calculation to a 40-60 calculation, a 35-75 calculation. I'm sorry, 35-65 calculation. I can do my math. Or 25-75 calculation. And those things will include things like adultery. The court can take that into consideration when deciding how to split up your property. Another factor there would be abuse. The court can take past history of abuse into consideration in deciding how to split the property. They're just little things. Just listen to whose fault it was that the divorce is taking place. The court can take that into consideration, and again, figuring out how to dispute this property. So yes, the court starts at the default point that what's marital property should be split up 50-50 during the divorce. However, unlike in communal property states, there are factors the court still listen to and take into consideration and change that 50-50 calculation. And also the other difference is liabilities or debts. I believe in the communal property states, those are also split 50-50. However, in an equitable distribution, debts aren't always split 50-50. If you want to split the debts in Maryland and both parties do not agree, you actually have to prove that these debts are marital debts. So let's say you had a credit card when you got married. Your credit card had a $20,000 balance, and at the time you're getting divorced, you owe $19,000 on it. And one party saying, oh, that's marital debt, so let's split it 50-50. But you can say, no, not all that is marital debt. Only $3,000 of that was earned during the marriage. The card is in the other party's name. They should be responsible for the other. They should be responsible for $16,000, and you split only that $3,000. But in a case like this, both parties have to prove that these debts are marital debts and that these debts were taken on because you were trying to help or trying to assist the family to grow or the marriage to grow, or because the other party was the one just spending like crazy on your credit card. Even if all $19,000 was spent during the marriage, but it was only spent by one party, the court isn't going to make the other party pay for it. As long as you can prove that, no, this $90,000, not a penny of it was spent by me, or only $2,000 of it was spent by me. The rest was spent on buying them, the other spouse buying jewelry or cars or PlayStations. Whatever it is, the court takes that into consideration. And that's the one good thing about the equitable distribution states. The courts actually has to take into consideration the facts of the marriage, what has happened in the past, before deciding how to split up both the debts and also the assets. And remember that equitable doesn't necessarily mean equal. It just means equitable, which is another word for fair. The court is trying to be fair to both parties. And it isn't really fair if you rack up a $10,000 debt in a marriage and then you expect your spouse to split that with you because you're now getting divorced. In Maryland, we say no, you racked up that debt on your own, you paid on your own. Now, if you racked it up because you were buying groceries, fixing the house, I don't know, doing things for the marriage, that's why you racked up that debt, that's when the court would go, well, no, most of this debt was racked up because you were paying for groceries. And I see the house repair bills or the water heater repair bills are on this credit card. This credit card was used for the benefit of the marriage and for the benefit of the relationship. Therefore, we're going to split it 50-50. That's what a court can do in an equitable distribution state. I just wanted to clarify that for people because I do get a lot of those calls or where the client always comes in and wants to talk about communal property estates. And I remember the first time I heard that, I had to go, well, let me look this up. But I'm like, no, we're equitable distribution states. It's all about what is fair. You present your case to the judge. The judge listens to the history of the facts and decides what's fair to both sides. So I hope that was a little bit helpful. Just because you're getting divorced does not mean you have to, especially if you're a guy, it doesn't mean you have to be necessarily financially responsible for everything. Because I've definitely had cases where the woman will rack up an enormous debt, come to court, and expect the court to split that debt 50-50. Actually, just wrapped up a case like this 2 months ago. She came to court with a $25,000 debt. She wanted my client to pay for it. And she gave her testimony about all the things that were bought on that credit card. But the first question I had to ask her, well, when were these purchases made? Those purchases were made before the marriage. How is that my client's responsibility? So my client did end up, it was a $25,000 debt. My client, I believe, ended up paying $1,500 on it because there was a big item that was bought for him during that marriage, and he had to go pay his share of it. That he paid, the court ordered him to pay it, but the rest of that $23,000 whatever, it wasn't on my client. So I hope that helps because I get those questions a lot, and not everyone's sure of what it means. You do the internet search and you see words and you don't realize that this is state by state, and every state has a different law. Okay, so I hope you found that helpful. Let me know down below in the comments. And if there are any other topics you'd like me to discuss or elaborate more on, just let me know. I would love to do that. Have a great day. And please do not forget to subscribe and like and all those other things YouTube tells you to do in order to get more views on other eyes. Again, I hope you found this helpful and have a great night.